Good morning. We are going to call to order this Judiciary Committee meeting. Are there remarks by? Sure, go ahead.
Hi, I just wanted to let everybody know, those folks that might be watching, folks in the room, that our wonderful colleague, Chairman Staffstrom, is ill today. So hopefully he's tuned in from his home, but he's convalescing from having the flu. And it's my understanding that my fellow ranking member, Representative Craig Fishbein, is participating remotely. So just wanted everybody to know that. Thank you. Thank you, Mr. Chair. And happy Valentine's Day, everyone.
Thank you, Senator Kissel, and hopefully people will see their loved one today. So we are now, if you're following along with the agenda, under Roman numeral number 3, which is remarks by the Office of the Attorney General with respect to the settlement referenced in Senate Resolution 13 and House Resolution 14. Good morning, and as soon as you're seated, you may begin.
Good morning, Senator Winfield and honorary members of the Judiciary Committee. My name is Eileen Meskel, and I'm the Deputy Attorney General for Connecticut. And with me from the Office of the Attorney General is Terry O'Neill to my left here. He's our section chief for our public safety section. We also have, I think she'll be back shortly, is Kara Passero, our chief of staff. And Assistant Attorney General David Yale, who worked on this case, is also present. To my right, Commissioner Quiros from the Department of Corrections. I don't know if there's anybody you want to introduce from. No. Okay. So I'll just proceed. We appreciate the opportunity to testify today in support of our recommendation to settle the case of Colleen Ward, Administrator of the Estate of Carl Talbot et al. Versus Carlos Padro et al., which was filed in the Federal District Court. This case involves the death of Carl Talbot. In 2019, Mr. Talbot was incarcerated for violation of parole in the New Haven Correctional Facility. A couple of days after his arrival there, in the early morning hours, he was in the housing unit, and he was screaming and yelling. The correction officers went to the cell, found that he was in distress, had been smearing feces on the cell and over himself. They offered to bring him to the shower to clean up and get clean clothes. He agreed. He went to the shower, did shower, but unfortunately failed to follow verbal commands to leave the shower. So he was then on the floor of the shower when he was sprayed with OC spray. Lieutenant Padro also kicked him in the torso. Shortly thereafter, he left the shower. They brought him down the hallway to be decontaminated from that incident, and his eyes were flushed. He was then brought to a wheelchair. He was dressed in clean clothing. They determined he could be brought back to his restrictive housing unit. They did restrain him. They put him in the wheelchair, restrained him in the front of his hands in the front of the wheelchair. On the way to the elevator, he did attempt to get out of the chair. While in the elevator on the way, he did get out and managed to get out of the chair and was on the floor. They decided to continue to bring him in the elevator that way. He was sprayed again in the elevator with the OC spray. After getting to his floor, he complied, left the elevator, went to his room, where he again was agitated. And there are times throughout this period where he's crying out and expressing discomfort and pain with his skin. In the cell, he was clearly agitated, asking to use the bathroom, claiming, saying he was trouble breathing, his skin hurt. And at that point, at some point, while they were in there trying to get him to calm down, he would not calm down. He was sprayed a third time with OC pepper spray. And then they determined they were going to put on in-cell restraints. And so there's a number of officers in the room. He was put in cell restraints that is not tied to the bed. They were just on his hands, and he was put on his back on the bunk. And at some point, the nurse does come into the room. They all leave, and they're required to do 15-minute checks, which there appeared to have been done, at least on video. But approximately an hour later, the new lieutenant on the shift arrives to see if they can remove the restraints, and Mr. Talbot is unresponsive. They call for a medical emergency. The fire department and the EMS arrive. Attempts to resuscitate Mr. Talbot were unsuccessful, and he was pronounced dead, I believe, at the hospital. That's correct. So the allegations in this case in the lawsuit are there's a number of different counts, but they primarily involve excessive force, indifference to serious medical needs, a failure to intervene, and then some additional allegations against Lieutenant Padro, who we do not represent. There were a number of officers who were sued here, and the nurse, Lieutenant Padro, is independently represented because we did not agree to represent him. He was charged with assault and battery, and he was convicted or pled. He pled guilty to that. My understanding is he also was suspended the actual day of the incident, which was, I believe, March 21st, 2019. He was suspended that same day and retired very shortly thereafter. In terms of this settlement, it's I don't know if I mentioned it earlier, but it's 3.75. It's in our proposal that we submitted to the legislature. And obviously, a number of the factors we look at involve the two of the spray incidents. He was not decontaminated, and he was not, neither was the room. And I would also note that at the time that EMS and the fire department arrived, they clearly were struggling with the amount, and this is, almost an hour and a half to 2 hours later, with the amount of spray in that room. They also noted some jaw stiffness, which means that there was some rigor mortis that had already set in. So the other troubling thing is about the validity of the checks and whether he was in distress at the time that they left the room. There also is I didn't mention this before, but after the incident, it was determined that a number of the required reports that needed to be submitted for incidents of this nature were falsified by some unknown DOC workers. And I would also mention that a lot of the incident itself, starting from the shower, is on a handheld video. So it's clear in terms of what happened from there to the time they left the cell, because that's all recorded. And so we have that issue as well. After all the depositions of the defendants and all of the evidence, it's our recommendation that this case be settled. And we're here to answer any questions. Is there anything else? No, I think that's all we have for the moment, but we're happy to answer any questions you might have.
Thank you, Senator Kissel.
Thank you very much, Mr. Chair. Well, it would be an understatement to say that the facts here are troubling. I'm just going to preface, and we had an opportunity earlier this week to bring me up to speed on this. I will state that I was not aware that this was percolating out there for the last 5 years, 6 years. But let me just say this, when I talk to folks, and I'm going to reference a very notorious matter, Jeffrey Epstein allegedly committing suicide in a locked facility in Manhattan, New York. And there's people that say, well, we don't think it was suicide because his hyoid bone was broken, and that can't be done typically through a suicide, someone hanging themselves. That only happens when someone's strangled. And then, people just speculate and they say, well, it was a locked facility. It was a correctional facility. It was right in the heart of New York City. How could anything bad happen there that we're not aware of? I'm not stating in this case that there was any mens rea or scienter or malice aforethought or intentional desire to kill this individual. But it does raise the issue that people can lose their lives in a relatively short period of time outside of any public view. And I'm not so sure that the result of this matter brings this individual any justice. Because, yeah, it's the Department of Corrections facility. They have cognizance of the lockup in New Haven. But I just think that if this was a lockup in any municipality's police department, which I'm more familiar with, that if in the space of a couple of hours, someone's son or daughter or husband or wife was dead, I'm not so sure that it would just shake out with a settlement and someone being able to retire and take their pension with a relatively modest plea agreement. And that's what we have here. You want this committee to review this matter and say $3.75 million taxpayer dollars. And according to my information, some upgraded policies. And we're just going to move along. Scary. It's really scary. I'd like to believe that I live in a state that is progressive enough that we don't have to worry about people getting killed when they're in a lockup. I just had a hearing earlier this week in the General Law Committee where we have people with great passion saying they want a law, and this is the proposed law that we heard just like 5 days ago in general law, that Connecticut cannot even manufacture anything that's involved in a death sentence carried out anywhere in the country. Now, I have problems with that regarding interstate transportation, and these are lawful practices in Alabama and Arkansas and other states and in the federal system. And so we'll leave that for another time. We'll leave that for the General Law Committee. But it's really ironic that at the same time that in one part of this building, people champion the fact that Connecticut does not have a death penalty. And I fought that battle and I lost. I thought there was a place for it in our state, but I lost. So for many years now, we haven't had it. But guess what? Somehow that was meted out, albeit unintentionally, I will grant you that. But an individual for a violation of, I don't know, dirty urine or something like that, essentially was given a death sentence. So let's just walk through this. I see a number of violations as to what was appropriate policy. First of all, what is with what we call this OC spray? What does OC stand for? And what is the policy regarding utilization? Because it sounds to me that it can only be used a certain period of times within a certain time frame. And that once it's used, that the individual it's used on has to be cleaned up, showered, decontaminated. I don't know the proper term. Their clothes have to be changed. So this has got to be some really potent chemical. So can either of you or the good commissioner please explain that?
I'll turn it over to the commissioner.
Morning, Senator Kissel and members. OC is chemical agent. There's a policy with chemical agent. There needs to be checked with medical for contraindication to see if the individual, if the chemical agent can be utilized with the individual. The proper utilization of a chemical agent is a 1-second burst, and it cannot be at a close proximity. In this case, well, furthermore, once chemical agent is utilized, there's supposed to be decontamination with the wash of the eyes, change of clothes, and change of the location where the chemical agent occur. In this case, there's 2 instances where policies were not followed, and the full decontamination was not completed, and Mr. Talbot should never have been left in that cell where that 3rd chemical agent spray occurred.
I'm glad that you acknowledge that, Commissioner. And by the way, you and I have worked closely together for several years, and I have the utmost respect for you. I always believe it's better when we have commissioners in the Department of Corrections that have experience here in Connecticut, have risen through the ranks. And it's my understanding that this incident took place when the commissioner was Commissioner Cook. And I believe that he hailed from Utah and he did not rise through the ranks here in Connecticut. Is that correct?
That is correct, sir.
So I'm just going to, rather than going through, and I'm sure some other folks may want to walk through the scenario, but we have the violation of policy in the utilization of this chemical, which apparently is a very serious chemical, should only be used once. And once you use it on someone, then the person has to be, for lack of a better term, decontaminated. And their clothes have to be changed, of which that policy was broken. I'm not even going to guess that there probably is a written policy that says you can't kick someone in the chest and debilitate them. But let's just get that on the record. Was that an outright violation of corrections policy, Commissioner?
Correct. There's never been a policy in the Department of Correction that says kicking an individual is authorized. So that was unauthorized strike.
And so we had that take place. So that's like within seconds of each other is the spray and the kick. The lack of decontamination of the individual. Then they're in a closed space, the elevator. Then they're put in a cell. And at the cell, there was it one more dose of the chemical agent or was it 2 more doses of the chemical agent?
1, sir.
So now we have a second dose of the chemical agent. By the way, just so everybody's aware, how old was this individual when this took place? Because, you know, when I first heard these facts, I'm thinking an elderly individual or something like that, where a chemical dose like this might really be something to be very wary of. But this person, to my knowledge, while there may have been some medical issues, was young and generally healthy. Would that be fair to say? How old was this individual?
He was 30 years old.
30 years old. Yeah, you would think that someone 30 years old isn't going to die in a lockup. But that's what happened here. So let's just jump, and I don't want to go on too long, but my concern is that I never want to have this happen in Connecticut ever again. Now, none of us have the ability to wave a magic wand and promise that there's not going to be bad actions or bad actors. I get it. But the problem that I have here is that we have an agent that is obviously so serious that it can contribute to someone dying. And what I'm hearing is, let's set aside the 3.75 million, which is divisible by 3. No great surprise there. Obviously, somebody's probably brought the case on a contingency, because when you see a verdict or a settlement that's divided by 3, that's usually why it's done that way. But okay, that's the dollar value that's been associated with this. But the policy change, or how we're stopping this from ever happening in the future. And here's where my concern is, and I don't know whether Attorney Meskel, this goes to you or Commissioner. If all we're saying is we're going to beef up the policy, but in the instance that this happened, the policy was violated anyhow, how does changing the policy get us any closer to making sure this never takes place?
So I have this week, I've authorized the reopening up the internal investigation in order to investigate the falsification of the documents that surfaced in this case. Policy is constantly on review when such incidents happen, and sometimes there's no change to policy because policy was there to prevent the incident. Last summer of late 2024, I met with a vendor for body cams. Came into central office and did a demonstration. I think that body cams are needed inside a correctional facility in order to deter this kind of behavior, this kind of tragic incident forever happening again. And you have my full commitment for the remaining term of my term as a commissioner, that I will try to do everything possible to make sure that this does not happen again. Part of it is the discipline too. And the frustration here is that the individual, the supervisor that was handling the incident, had a 20+ year. So when he was placed on administrative leave that same day, 8 days later, he retired from state service with a pension. If that individual had not had 20 years, that individual under my leadership, terminated. I take these incidents very seriously when it comes to excessive use of force, when it comes to the failure to intervene, when it comes to the failure to report, when it comes to retaliate against a staff member. And there's been cases that have come up in front of me as a commissioner that harsh discipline, to include termination, was the discipline. And that is my commitment when it comes to these types of incidents and not following policies. So again, you have my commitment that I'm gonna try everything I can. And if I may, I'm not sure if this is appropriate, but I'm gonna do it anyway. I had the opportunity to meet Ms. Lohr at a mental health symposium in 2023, and I apologize to her. And again, I want to apologize to Ms. Lohr and her family for the pain and the loss of her son in the hands of Department of Correction.
Well, I really appreciate that, Commissioner, and you're a straight shooter, and I've always admired your leadership in the department. It's not always the case, and this is not a political thing. I have been very upset with past commissioners under Republican administrations, Democratic administrations. It doesn't matter. But I actually am very happy with much of what I see in the Lamont administration. And you're one of those individuals that I respect and admire. So if you're putting these changes in and you're committing to it, that's very reassuring. And I think it's reassuring to my constituents. The fact that there was a falsification of records, and here it is 5 years down the road, and we still don't know who was involved in that. That is troubling, and I'm very grateful that you've ramped up this investigation, and hopefully we'll get to the bottom of it. I just have one last point because I think it's important, and then if you want to add something, by all means. The last point is when we reviewed this earlier this week, and my initial reaction was really amazement, and that's putting it kindly. But one of the things that I believe I heard was that I think it was the mom of the person who passed or someone involved did a video, and that somehow the tragedy that happened here is now part of training for either current corrections officers or new corrections officers, that when you put real person behind an incident and you see them talking to you, that it can really drive it home, and that can go really, really far to making sure an incident like that never happens again. Can you just explain that? Did I hear that correctly? And how is that going to go forward?
Senator, that's correct. Part of the settlement agreement in this case, and I should have mentioned that because you're absolutely right. We totally echo your sentiments that this should not have happened and shouldn't happen again. But the mom in this case, part of the settlement agreement, Colleen Lord, is going to do two things. One, she's going to present the human element to training that occurs in person for a period up to an hour, I believe. And the second point is for in-service training or training that's for like new supervisors and supervisory training. She's going to do a video for the other component of training that isn't in person or that's in-service training. And that I think is super important. Nothing provides closure. I agree with you, but I think that in this instance, goes a long way to hopefully not having something like this happen again.
Well, I want to thank everybody involved with this. It's got to be a difficult case to handle. I mean, there really wasn't a lot of great defenses that you could throw up. And I think the resolution is as close to justice as we're going to be able to attain on this lifetime. You can never roll back the clock on loss of a life or loss of limb. And I appreciate the fact that under your watch, Commissioner, that you're committed to making sure something like this never, ever, ever happens again, and that you're equally as committed to getting to the bottom of the falsification of records issue as well. And I want to thank my chair for his indulgence in letting me ask some protracted questions, but it's a serious situation that I think sometimes we think very highly of ourselves in Connecticut, and justifiably so. But that doesn't mean that we're perfect, and it doesn't mean that something bad can't happen here. And we like to pick on other states like Arkansas or Alabama, or I don't want to pick on anybody, but we like to think, oh, we're just way down the road, or we're more progressive, more understanding. That would never happen here in Connecticut. And then you wake up and you realize, yeah, it can happen in Connecticut. So thank you, Mr. Chair.
Thank you, Senator Kissel. Representative Fishbein.
Thank you. Good morning. Thanks, Chairman. I wanted to start with just go, and I want to thank Senator Kissel for his remarks, which I do align myself with. My understanding is standard operating procedure is that prior to using a spray like this, that medical records are supposed to be checked to see if the individual will have an adverse reaction. Is that accurate?
Yes, Representative Fishbein.
And in this case, did anybody check those records?
It was not done.
And I appreciate the body cam situation, and I do think body cams are good, on both sides. But clearly that breach of standard operating procedure would not have been cured by body cam. So, moving forward from there, the sprays, and we sort of heard that the distance from the spray was important. That's part of standard operating procedure. Also, you're not supposed to spray closely. Is that fair?
Yes, Representative.
And in this case, I think the evidence showed that each of the sprays were about 6 inches from the deceased's face, correct?
Yes, Representative.
So that would be a breach of standard operating procedure.
Yes.
We sort of dealt with the decontamination issue that was not followed either. So I'm going to shift to the monitoring. So what's standard operating procedure with regard to somebody being in restraints in a cell as far as monitoring? What's supposed to happen?
Can you repeat that question again?
Sure. When somebody is in restraints in a cell and they need to be monitored, what is the procedure that is supposed to be followed?
He was in the restricted housing unit, and that housing unit, the tours are conducted every 15 minutes. There is a document checklist that the officer conducting the rounds is supposed to sign, and they're supposed to look into the cell and ensure that there's living, breathing individual. If there's no sign, they should be knocking on the door or calling the individual's name.
So what triggers the 15-minute review? Is it the person being in that particular area, or is it the restraints or something else?
It was the housing location of the individual. It's a 15-minute tour unit.
Okay, so there is no procedure currently under DOC that, once you've gone to the level of not only the housing, but restraints, there isn't a more escalated review, let's say every 5 minutes or something like that. Is that fair to say?
If an individual is put on one-on-one observation, that is some constant observation, and that officer has to make a log entry every 15 minutes.
Okay, and have we been able to ascertain whether or not the monitoring procedure was properly followed in this case?
I must say no, it's not properly followed.
So shifting to the falsified documents. Now, my understanding is that this case was filed just under 2 years from when the bad acts happened, actually 3 years. Is that fair? There's about 3 years post-incident, the lawsuit is brought.
Yes,
And in the meantime, in that intervening time, I would expect that there was some sort of discussion between representative counsel for the estate with the AG's office. Is that fair?
no, that is not correct.
Okay, that's fair. But when the lawsuit is brought, it's alleged that, and that's brought February 28th of 2022. It's alleged that an individual with the last name Brookshire was involved in the spraying. Correct?
That's correct.
And it's not until a year and a half later that it is ascertained that the documents that support Brookshire being involved in that spraying were falsified. Is that fair?
I don't know about the time frame in terms of, I will say that at part, when we get a lawsuit, we obviously get immediately with the agency, and part of our attorney-client review is reviewing records and discussing with individuals. So we certainly became aware that information was not accurate.
Okay, so I'm just looking at the timeline. So the actions brought February 28th of 2022. No action is taken with the federal court to remove that individual and to admit, so to speak, that documents were falsified until August 9 of 2023, which is 1.5 years later. So, I have to, I got the attorney-client privilege, right?
Mhm.
I would think that upon filing of the lawsuit, that people would be asked about their involvement in this relatively early on. And I don't want to pierce into attorney-client privilege, but that seems like an awful long period of time. And, my concern is that statute of limitations is running, right, on falsified documents. And filing false reports and all that stuff. And as we sit here today, or at least at the time that there is recognition of falsified documents, I believe the statute had run at that point, correct?
You mean a criminal statute? Is that what you're referring to?
Yes.
Yeah, that I'm not familiar with that. Yeah, I don't know either. That's probably accurate though.
Because my understanding is there were initials on at least one falsified document, and they indicate CP, which more than likely Carlos Padro, who I know a lot of the fingers are being pointed here. And he was not charged with anything having to do with falsifying documents, right?
No, that's correct. He was not.
So is Padro the only individual who did something wrong in this case?
If I'm going to make an assumption and you can correct me, if you're talking about criminal liability, he was the only one, because there was an investigation by the state's attorney's office and state police. He was the only one who was criminally charged. I think what we've said and sat here today is there were mistakes and failures on a number of correction officers' parts, but he is the only one who was actually criminally charged.
I appreciate that. The cause of death on the death certificate is homicide. Gentleman was not charged with homicide. I understand there was an investigation, but was anybody written up for violating policy?
I'll let the commissioner respond to that.
From my review in the incident, the lieutenant was the supervisor handling the incident. The 3 instances where chemical agent was utilized, that was at the judgment of that supervisor. The officers that were in the cell used force to hold the end Mr. Talbot and for the restraints. The other individuals with the checklist, the investigation at that was unable to determine who the individuals that falsified the document, so there was no discipline for that.
So there's been no retraining of any of these individuals. I believe there was over a dozen that are part of this lawsuit. None of these individuals have been retrained as to what proper procedure is. It seems to me like a lot of people made a lot of mistakes.
The remaining individuals that remain working for the Department of Corrections have attended the annual in-service training, and it is a 40-hour training session that speaks about use of force, chemical agent, and reports. So they've gone through the annual training for the agency.
Thank you for that. My last area, there's one lawsuit here, and am I to understand that Padro, who was pled guilty to assault third, got probation as a result of a homicide? Is he going to get released from liability if we accept this?
So the release that we have as part of the agreement includes it doesn't specifically reference him directly in terms of his name, but the release does include all former and current correction officers so that the state doesn't continue to have any exposure to liability. I obviously don't know what discussions have taken place between Attorney Padro's attorney and the plaintiff, but my understanding is that all of this will be resolved, that there would be nothing remaining of the case.
And what is Mr. Padro's contribution to the $3.75 million?
Well, he's not contributing to the 3.75. That is something we're asking. We're here to ask the state to provide.
Okay, so essentially you're asking us to accept a settlement agreement which alleviates an individual who was arrested and convicted of a crime that led to someone's death, an intentional act, because there's got to be mens rea for a criminal case. Why do you think it's in the best interest, since you're not defending Padro, why is it in the best interest of the taxpayers in the state of Connecticut to include him in this settlement?
Well, we're asking for the settlement on behalf of the state because of the failures and other actions of the other defendants in this case. And the risk that a jury, although they certainly, in my opinion, likely would award something specifically against Lieutenant Padro, would also, in the risk of litigation against the other remaining defendants. And so we're here because of our representation of the, other defendants in this case. Some of the original defendants are no longer part of the case, but we still have a number of remaining defendants. And we've talked today about the failure, and there was no one ever charged. And there was a finding that none of these other officers, including Lieutenant Padro, obviously actions rose to the level of a murder or frankly, any other crime by any of these other defendants. And so that's why we're here, is the risk to remaining defendants and what a verdict would look like if against them and the state, if this case were to proceed.
Well, I respect that. I have a lot of problem with including this individual who more than likely fraudulently created a document, right? Nobody's saying otherwise. And somebody is dead. The gentleman kicked the deceased in the torso after he had been sprayed. I really don't see why he should be part of this settlement. That's one of my biggest problems. I understand the aspect of Miss Lord being involved, and that's perhaps it's a novel aspect of this, and I think it's more than likely helpful with her through the grieving process. But I don't know that I can support this. I think I'm shirking my duty. When somebody has been charged, convicted of a crime that led to someone's death, an intentional act, why they're not being held liable for this. So thank you for coming here today, and I look forward to hearing what my other colleagues have to say. Thank you, Mr. Chairman.
Thank you, Representative Fishbein. Comment or question from other members of the committee? Comment or question from other members of the committee? Representative O'Day.
Thank you very much. Sorry I was late. I was listening on the way up. Good to see all of you there and appreciate your testimony. And good to see you, Attorney O'Neill. The question I have to follow up on my ranking member, and I do align my self with the remarks of both the ranking members. Is there a possibility of getting some form of identification from the perpetrator?
I'm sorry, you're referring
Yes.
from Padro. I assume that's what you're referring, for us to get some sort of monetary.
Yes.
So we haven't, again, when we look at a proposed settlement, right? And we look at what our exposure is. I want to also emphasize, because while I certainly condemn what he did, it was in terms of the actions and the kicking and all of that. I want to also emphasize that there was not found a connection or a causal link between, let's say, the kick, right, and the death of Mr. Talbot. And so, I mean, there's a lot of factors, obviously, that go into what we think our exposure is on the back end. We didn't look at which can happen in a given case, right, depending on the particular actor and what the other involvement is. But it becomes an issue, certainly, of finances and resources. And I'm making an assumption because he does have his own attorney, and the plaintiff attorney has had discussions that they've made that determination. And if there is some side agreement, then we're not aware of it. But I don't think that's something, we're not presenting that as part of our recommendation. We're simply looking at what we think our exposure is. And let me just address the release issue. Is we need to have the broadest type of release, so we don't, have a claim later by as Lieutenant Padro or any individual that they're entitled to some type of indemnification, and so or claim, and or that we're exposed to yet another. And so we're obviously trying to do our best to make sure we've cut that off. There are cases in which we settle where there are other remaining defendants, and the case does go forward with those. That's not what's happening here, but I want to emphasize that does happen in some situations.
Yeah, look, I've settled a lot of cases where you want as broad a release as possible to eliminate any potential of an additional claim later on. It is, and I've settled a lot of cases where we have contribution. A lot of times it's a nominal amount, but contribution $1,000 a month, $2,000 a month, some contribution for a number of years from individuals beyond whatever insurance or other payment may be made. It is Mr. Page, is he getting a pension, for example?
I believe he is.
Yes.
Yes, he is, Representative.
Okay. So, so as far as you're aware, he's not making any payments to the plaintiff or anything towards the settlement. Is that what I'm understanding?
That's my understanding. I obviously couldn't say that with 100% accuracy, but that is my understanding.
You know, I'm trying to think of a time where I settled a case where I didn't know what other payments were being made to a plaintiff, and I frankly can't think of one. So I guess as part of the settlement, can we demand that we know what other payments are being made from any of the other defendants?
We can certainly ask the plaintiff's attorney. It is our understanding based on what was represented to us. And I say it can't be because we're not party to those conversations, that there is not another payment being made.
So are we, by executing this release and agreement, are we precluding ourselves from trying to be indemnified from his pension, so to speak, or as a possible option?
Yeah, we don't have a current statutory authority like we do in some cases where we can go after employees, for instance, in the fraud department, right? Former employees who committed, where we have a statutory authority to go after pensions. This is not one of those situations.
Fair enough. All right, I appreciate the responses, and I do trust and believe that this is the best resolution we could possibly have on behalf of the state, because having known Attorney O'Neill for many decades, I trust him, and I appreciate your hard work on this. Thank you.
I'm honored, Representative. Thank you.
Thank you, Representative. I don't even know where to start. So let me just start by trying to make sure I understand what I've heard today. So at the point of the elevator and the restraints, do we know why the individual was sprayed with the OC at that point? If they were restrained?
Are you talking about?
Yeah, sorry.
Oh, yeah, sorry. Well, I mean, I obviously know what was in his mind, but when he was being brought to the elevator, he was in the wheelchair, restrained with his hands in front. And he was trying to get out of the wheelchair, like trying to stand, trying to get out of the wheelchair. And when he was in the elevator, which is pretty small, it's not a large, at least that was my view of it. It was a very small elevator. He's continuing to try to get, even being told not to do that, of course, but continuing to try to get out of the chair. And so it was at some point he gets out and is on the floor. And I believe that's when he was sprayed for non-compliance. It was when he was in the elevator on the floor, not on the way to the elevator.
Yes, go
All
ahead.
right, Senator. Thank you,
Oh.
Senator. I've reviewed that video, and there was no reason for that capstone to be utilized. Even if he was not following direction, he was in a close, small space, and that capstone even affected the officers that were riding in that elevator too. So in my professional opinion, that chemical agent should never been used in that elevator space.
Thank you. It seems pretty clear, but I don't do this work, so I have to ask. In the cell, when he is sprayed, is it one time or is it how did that occur?
Once they get to the restrictive housing unit, the elevator opens, he is escorted into the cell. Once in the cell, again, gets on top of the bed, is not following direction from the supervisor. The supervisor makes the determination and the judgment that he was going to spray the individual again. From the video I saw, there was only one spray in the elevator. So there's one spray in the shower floor. The second spray is in the elevator. The third spray is in the cell. And that was all captured in the handheld video.
And the third spray that occurs in the cell, I'm
Correct.
assuming it's not a 1 second burst.
It was not a 1 second burst.
And you saw, you had video of that too as well? I don't remember if you said that. There was video of that as well?
There's video of the.
How long was that?
Probably anywhere from 2 to 4 seconds.
How small is the cell? Because you said that an hour and change later, there was still difficulty by the individuals who came to help. And it seems like
I think
that, yeah.
I think it's 8x11. So
And that's it. In your professional opinion, that seems like there would be that level of OC spray still in the cell. I recognize it's small, but that still seems like a lot an hour plus
There-
later.
there was 2 hours later, New Haven Fire Department and New Haven EMS. You could see them on video, having trouble breathing inside of that cell. So I must say that there was enough OC spray in that cell that the supervisor discharged that 2 hours later still had an impact on the medical emergency personnel that responded to the incident.
Okay, so let me ask this question. So there was one individual who had criminal ramifications. That individual is the individual who kicked the victim here. Were they also the one that sprayed this person? And if so, did they spray them in all three times that the spray was released?
Yes, all the same, supervisor.
Okay, all right, that clarifies at least part of it. On the issue of falsification, when did I know Representative Fishbein asked this question, but when did we find out that there was falsification?
So the internal investigation by Department of Correction determined that the checklists where the officer were documenting the tour, that document was falsified. And it is my understanding that the incident report, the use of force and the critical incident report that has CP on it, that came to light during the supervisor's court appearance. The report with the officer Brookshire, that came to light during deposition. Her deposition.
Okay, maybe I'll attack this a different way. So the internal investigation that you're looking to go back and do now, is that the same one you're talking about in response to my last question, or is that a different thing?
It will be different because we will not just be focused on the checklist. We will be focused on the documents that were falsified that had the initial of the supervisor, and we will also be looking for the author of the chemical agent that had the false signature of the officer.
But let me clarify, because you use the word reopen, so it may not be exactly the same things that you search for, but it's related to that prior investigation.
Correct.
Okay, why now?
So one of the policy changes that I'm changing, Senator, and is that investigations that reach the level of the commissioner's office has to do with the discipline. And I review investigations that are 5 days of suspension and above. So I have changed that policy that regardless of the discipline level, that these investigations needs to reach my office. So I take full responsibility for when the investigation was completed, I believe in February 2021, that was not brought to my attention. And at that time, the only thing that was in the internal investigation was the falsification of the checklist. That investigation did not cover anything to do with the falsification of the supervisor's report or the Officer Brookshire's report.
I guess my question is, there was an investigation. You later find out that there was falsification. Your office was aware that there was a falsification
My
prior to 2025, correct?
I became aware again, and this is why I'm changing the internal policy. I became aware of the violations. The first time I reviewed that investigation was when the AG's office put it on my radar that we were going to be coming in legislation 2025 for a settlement. At that point, I requested the investigation, requested the video, and that's the point that I became aware of these violations.
So I'm really confused about how we operate now. So you are unaware for close to 2 years that there's a falsification by folks under your supervision. That's correct?
Correct.
How is that possible? Why is that possible?
The investigation never reached my office because the discipline level was a counseling session. In the case where the supervisor still was working with the department, the discipline would have been much harsher, and that investigation would have reached my office, and I would have been aware back in 2021 of the violation. And that's the reason that I've changed the policies, that regardless of the discipline level, that these investigations need to reach my office.
I don't even know what to say to that. That seems almost unbelievable that something like this can occur. I'm not blaming you necessarily. I don't know where to put blame for that. Something like this can occur and you would be completely in the dark on it.
As the commission, I'm taking full responsibility for that, sir.
I appreciate that. It's more important to me to figure out how these types of things come into being and how do we proactively make sure that we don't get into these situations. So while I appreciate you taking that responsibility, I'm not sure it lays completely at your feet. I know that there are questions from others. I'll just say this, and maybe I'll say something else. First, with all the respect that I have for you, you and I have known each other for quite a while, and we've been able to work together. I don't think this is just an issue of whether the commissioner was raised up in the state of Connecticut. I think this is an issue of how our prison system works and how recalcitrant it happens to be whenever someone tries to do something under the title of reform. And how, for many years in this state, I've been pushing us to do more and better. And at every instance, whatever the ultimate outcome, at every instance, there is pushback because you're not a corrections professional. But it is corrections professionals who do these things. And so my level of frustration is about as high as you would have imagined before you walked in here, Commissioner. I know you know that. It doesn't make sense. A lot of what is happening here is not just the instance itself, but all of the stuff that allows for the instance to play out in the way that it plays out does not make sense. And it's not just about the particular family, though it really is about that family. And I feel for the mother in part because I know her, but it's also about the people of this state and the ability of the people of this state to look at the professionals and say, there is a system in place that works the way it should. And when something happens, it functions the way it should. And clearly, that is not the case. It clearly isn't. Let me just ask this question to those who are dealing more directly with the settlement, and then I'll go to Representative Howard. I listened to Representative Fishbein, Representative O'Day asked you questions. I'm not an attorney, so maybe I just don't know how these things work. But I don't understand why the state can't come up with a settlement where the state, because we are doing a settlement, takes care of its issue of liability and leaves those individuals so that, you know, what I'm talking about when I say we look at these systems and we say these systems function in a way that doesn't make sense to the people, right? And it affects the people's ability to look at the system and trust it. What the way we do things, if I'm just sitting as a member of the public, I say, I don't think they have to do that. Pretty sure you don't have to do that. I don't think they have to do that. And they just cover these guys. And these guys never have responsibility. So what makes them feel like they need to be careful? What makes them think like they have something on the line? Why do we do it the way that we do it? That's a slightly different question than you were asked, and I would really love an answer to that.
So I'm going to try to answer your question, because look, we understand the frustration of there's a lot of cases overall, a lot of state employees, and in this particular case, a lot of failures, right, by a lot of individuals. But, and I've been working for the state for a long time, and so has Terry. There is a policy and there's a statute in 5-141D, which requires us to, and I say us, first the state in general, to indemnify state employees when there are certain situations. And the only exception to that is when they are wanton, willful, or reckless. It leaves the determination to our office to determine whether we're going to provide a defense to particular state employees. And we take that responsibility very seriously. We review everything when they're sued individually. We review all of that. We work with the agency who investigates and determines. And but we look at what the policy is and what the statute requires, which is not just wanton, reckless, and malicious. That's where the exception is, but it's by any alleged deprivation of any person's civil rights or other act or omission resulting in injury or damage. And so it's a challenge, of course, in many of these cases. It's not just corrections, it's obviously other agencies as well when they have public facing situations. And so, you know, I would agree with you. You know, how do we get acknowledgement or a change when that has happened? Of course, they are still being sued. That in itself is stressful, but really it comes down to, you know, and every situation is so fact specific, but talking about the policies in place, making sure that the agencies and the individuals going forward, we need to learn from everything, but that there's going to be some punishment that occurs. And it's unfortunate when that doesn't happen, right? And I know there's a lot of frustration about that. But, you know, that's the guidance we follow when we're defending these cases. I hope I answered. I know what
it is more than unfortunate. This individual just did not follow the rules. This individual operated in a way that was deliberate. You said it yourself. He didn't accidentally kick this individual. You don't accidentally spray this person this many times. This individual, maybe I can't say that this individual intentionally harmed the person, but I think the facts actually lay that out. And this person operated without care. I don't know how you don't look at it as those three things that allow you to separate this person. What I think, as a person who has been involved in these things for a long, long time, even before I ever came here, is we operate in a certain way, we continue to operate in that way, and we need to change it and be more thoughtful because it's not just unfortunate. Representative Howard.
Thank you, Mr. Chairman. Just a couple of brief questions. One is just a clarification for me. One of my colleagues earlier in a dialogue mentioned that Mr. Talbot, the victim in this case, was 30 years old and generally healthy. I've been to the documents, and the documents that I read, in fact, showed his cause of death to be, in addition to him being sprayed and constrained the way that he was, restrained the way that he was, arteriosclerotic and hypertensive cardiovascular disease and morbid obesity and also an asthmatic. Did I misread something in the OCME report or?
No, that's correct. That's what the medical examiner found.
Okay, well, I guess maybe there's generally healthy is probably a subjective term, but I just wanted to make sure that I understood that. I don't have too many additional questions. My colleagues have covered it. Certainly, there was some catastrophic failures by personnel in this case. But the one thing that I want to and I think Senator Winfield was sort of getting at this, one of the things that stuck out to me is the documents reference exhibits, and I don't have the exhibits, but one of the exhibits that it references is a handheld camcorder. Now, my experience has been that at times DOC operates and one officer will hold a camcorder. Is that what happened in this case?
Is the question whether the use of a handheld camcorder is a regular occurrence? I'm not sure we understand the question.
My question is, was with a lot of this, it appears that a lot of this incident was captured on video. Is that true?
That is correct. There was a handheld video incident from, I believe it started around when he was in the shower and ended when they left the cell, left him in the cell.
Right.
And then started up again later, but that's the main body of the incident.
Understood. Thank you for that. So what's extremely troubling to me, obviously if this incident, it shouldn't have happened. As I said, catastrophic failures, I acknowledge all of that. And I also acknowledged, Commissioner, that it wasn't under your command at the time. And I respect that and appreciate, where you were at the time. However, there was an internal investigation done by DOC, and that had its own failures. Right up to and including Brookshire, according to documents that I read, it wasn't, and I think the commissioner said this a few minutes ago, it wasn't until deposition that it was determined that Brookshire wasn't there. Am I correct understanding that?
Yeah. I think that's when it came out publicly. I would say that obviously in terms of when we're prepping witnesses, we would have certain information prior to that.
All right. I understand that. What I'm driving at is I conduct investigations for a living. I mean, the most fundamental fact to be able to figure out, especially when it's on video, is who was there. And it seems that the internal investigation with DOC couldn't even get that correct. Am I right?
I don't know if that's.
I believe you're right, Representative Howard.
Can if I may, can I just also, because there may be some confusion about this point, but after the death of Mr. Talbot, there's a criminal investigation. And so while that's ongoing, there's nothing happening at the DOC level in terms of an investigation. They have to wait until that concludes and see what charges, if any, is happening. And so they are also, as part of that investigation, they are reviewing all of the records in the video, but that happens first. And then when that's concluded, DOC could do something at that point.
Okay. So, the Senate chair, essentially, I'm going to say something that I think is along the same lines. And I've made this argument, I don't know, since I got to the legislature and probably long before that, where there's no enforcement or accountability, compliance with laws or regulations goes down significantly. That's human nature. Some people may disagree. Some of my colleagues disagree with me about this. But what I'm driving at is, there's nothing that we can do to go back and change what happened in this incident. But we should be taking every necessary step to make sure this doesn't happen again. So my question is, obviously, if an incident like this were to occur now, under our current legislation, current laws, it would be investigated by Inspector General's office because it would be an in-custody death. how are investigations conducted in DOC now when there are complaints from inmates regarding use of force that don't rise to a fatality?
They are conducted by internal division, security division, and the complaint is received. The evidence is reviewed at times. The majority of the time, there are videos that capture the use of force. So that's reviewed. Any stationary camera in the location will be reviewed. There will be interviews from staff and the offender population to clue. And then we will run it by the academy, Captain Quijano, who is our expert witness when it comes to use of force and testifies for us in court to see if the use of force that was seen in video was justified. If it's not justified at that point, the investigation is concluded, due process happens, the individual will give an opportunity for a laudermill, and then the discipline will be recommended, and it'll come to my office for the final discipline. Since being the commissioner since 2021, I have terminated several individuals for excessive use of force.
All right, thank you, Commissioner. And like the senator said, you know, I mean, you and I have spoken a handful of times, and I've had great, you know, communication with you, and frankly, respect for the job that you're doing since you got there. So my final question to you: are you confident today, as we sit here, that your IAD is doing a significantly better job than the failures of IAD in this particular case?
Yes, I am confident, and even more confident because since 2019, and hope continuing to the future, that we never experience this type of incident. This incident is an embarrassment for me. It's an embarrassment for the agency. And when you're considered a law enforcement agency, the worst thing you can do is violate the public trust, and the trust from the elected officials, and the trust from the population that we supervise, and the citizen of the state of Connecticut.
Okay. Thank you, Commissioner. I appreciate your answers. Senator, thank you for the time.
Thank you, Representative. We have one member who is not identified online under iPhone. You could identify yourself. Maybe I can call on you.
Sorry, Mr. Chairman, it could be me, Doug Dubitsky.
Your hand was up. Yes, it's you. You may proceed.
Yes. Thank you. Are you not able to see me?
We can see you now.
Okay, great. Thank you for coming in to testify. I apologize. I was in another committee meeting. So if my question is redundant, I apologize. What is the amount of the settlement that you're asking us to approve today?
It's 3.75 million.
Okay, and how was it, to the extent that you're able to say so publicly, how was that calculated?
Well, obviously it's a long negotiation, but whenever we look at settlements, we try to make a determination, obviously, of worst case scenario, what our exposure is, what other cases have come in at. And, you know, there are not just in Connecticut, but in other states. And frankly, they range from, I'm going to say, a low of around $1 million to a high of 12 million for either suicide deaths or indifference to medical needs, to other deaths in correctional facilities. And so, you know, obviously the age of the plaintiff in this case is a factor. We recently had a case in federal court, which did not involve a death and actually not a really serious injury. And there was an award of almost $1 million, a case that we actually felt very confident about. But this is the risks that we have when we proceed. And so it's a number that it's a back and forth, but it's a number that we obviously felt comfortable was the right number. Obviously, both sides compromise as part of a negotiation, and along with the non-monetary components, which we discussed earlier, and that's why we're recommending.
Okay. Well, thank you very much. And I appreciate your coming in. Thank you, Mr. Chairman.
Thank you, Representative. Vice Chair Gacon Wilcox.
Thank you, Mr. Chair. I just wanted to first to echo the comments of our chair, Senator Winfield, that clearly this is very disturbing, but that we really need to sort of look at how our system is functioning and whether we're addressing what he has been advocating for a long time of the systemic flaws. But then I just wanted to follow up on a question. I think it was Representative Fishbein that asked this, that the individual that is really responsible for the most egregious conduct, is he included in this settlement because you have determined that his conduct was not willful? Was that a discretionary determination? And is that why he's included? I'm not clear why he's included in this settlement. If you can sort of explain that further, I would appreciate it.
Sure. I think it gets confusing because he's not included from our standpoint in the settlement, in that we're here on behalf of all the defendants that we represent and we are defending. But he's included in the release in the broadest sense of the term. And so what we're and I also just want to reiterate, because we all feel the same about his actions in this case, but and he was charged, but he was not charged for the actual death of Mr. Talbot. He was charged for assault. And so again, although we were including the release would cover him, we don't consider him, I guess, included for purposes of why we're here and what we're asking for.
And
I know
it's
a technical difference. And
I understand. But was that determination made because the conduct that he was charged with is not considered, his behavior is not considered willful and wanton? And in other instances where you have individuals who did have willful and wanton conduct, would you exclude them from a settlement?
Well, it depends on a lot of factors, but in terms of what we look at in this case, we did exclude him from representation. And to the extent that, right, there was an individual that we have excluded, which is not often, but we do that. And we do feel there's a direct causal connection and that our exposure is less limited and we are less at risk in terms of going to trial. That is a consideration in terms of the amount that we're willing to either settle for or bring forth to the legislature. So there's a lot of factors that go into that. He wasn't charged here with that. There was no direct connection. The state's attorney's report specifically found that no individual's action could be the basis for a criminal prosecution for the death of Mr. Talbot. So that is certainly something that we have looked at. There are other cases where we settle for our piece of the case, and the case remains for other remaining defendants. That is not what's happening here, although that could have been the choice of the plaintiff, I presume, if she had decided that she wanted to do that. But my understanding is she chose not to do that.
Okay, I see. But the determination, though, to include or not to include on your part is based entirely on the charges from the state's attorney. It's not a discretionary sort of determination based on the standard of whether you think the conduct separately meets the, willful and wanton.
Well, we don't represent him, and we chose not to represent him, and we did cut him loose. And so that was based on the criminal charge of assault. And what we do is we assess what our remaining liability is after we cut an individual loose and look at what a jury potentially would do with who's responsible for Mr. Talbot's death. And one of the factors we have, unfortunately, is that he was not found to have caused the death, but we didn't include him in our defense and our representation. So he has a separate attorney. And as I said, if the plaintiff in this case, if they had chosen to, and I understand, that's their choice, they could have pursued the case directly against him and continued on and gone to a trial if they had wanted to.
So would his inclusion in this case, sorry, last question, would his inclusion in this case impact in any way liability that he may face in other contexts, in other criminal or civil proceedings?
I'm not sure. I understand your question. I don't, at this point, he was charged for this particular incident and he was sued as part of this incident. And so I suppose if you're asking me, if he were still working for the state, which he's not, would that be a factor in another case if he did something similar? It certainly would be a factor for us in reviewing that if he were sued again, and it could be a factor. But, he retired very shortly after this incident, and that was back in 2019. So I'm not aware that there would be, it is a factor. I mean, he pled guilty to that charge, and he has been sued and he has to disclose that. I'm not sure if that answers your question.
Yes. Yeah. Thank you.
Yes.
Thank you, Senator. Are there comments or questions from other members of the committee? Representative Quinn.
Thank you, Mr. Chair. And I also appreciate the effort that the Attorney General's office has put in on this. But, and I don't want to keep harping on this, but I guess I'm struggling to understand that if we cut this officer loose for purposes of representation in the case, then why are we including him in the release? I mean, we could certainly release our part of the case and the case against the officer could continue to go forward. So I'm just not getting why he's included in this release.
Well, part of what we do is I suppose he wouldn't be included if the plaintiff had asked us specifically. I think the exposure for us is because we can, in fact, there's a possibility that he would come back to us for indemnification if the case had proceeded against him. In fact, he has tried to require us to represent him through a different lawsuit, which, we have declined to do on a couple of different occasions. And so since the plaintiff does not want to proceed against him, we don't want any remaining exposure out there from anyone. And so that's our goal, is to include the broadest, the individuals who are named in there are the individuals we represent, but we did include broader language that covers any former or current correctional officers or state employees, right?
Was his attorney involved in the negotiations at all to reach the 3.75 number?
No. In the sense of they had their own separate negotiations, he was not involved in our particular negotiation.
Okay. All right. Well, I'm still struggling to understand how we're releasing him if we're not representing him, but I see your point, but yeah, I don't get it, but thank you.
Yeah, I guess the confusion is, well, the release includes it. It's really because the plaintiff has chosen not to proceed. And so we're covering all the parties are covering all aspects of the case.
And I would assume that that was a representation from the plaintiff's attorney.
That's correct.
Okay. All right. Thank you.
What was the representation from the plaintiff's attorney that the plaintiff didn't want? What? I missed that.
They don't want to. They're not going to proceed separately.
The difference between not going to proceed and what the plaintiff wants to happen, right? And oftentimes, particularly with people who are not immersed in what you and I, the world you and I are immersed in, to suggest that they don't want to do something is not accurate because they may not know. And so I'm just clear because we're on a record here.
Right. Let me clarify, because what, obviously, I don't know what is the release itself is something that's reviewed and negotiated between both the plaintiff's attorney and our office. So that's something the plaintiff's attorney was supportive of.
But it doesn't necessarily have anything to do with what the plaintiff knows or wants to do. And this is the way that we normally operate. So it may not, I'm not going to get into the discussions between you and the plaintiff's attorney, but it's very much what we do. I'll stop. Representative Fishbein.
Thank you, Mr. Chairman. You know, quite obviously, Mrs. Lord wants to be part of this process. She's part of the settlement. She has a vested interest in continuing on. You know, and I have a lot of difficulty, as does the chairman, with representations as to what the plaintiff desires, because this number, if we apply the but for, which we many times do as lawyers, but for this particular act, what will be the result? This number settled, paid by the taxpayers, is too large. I'm sure that Mrs. Lord would want to, well, I would more than likely think that Mrs. Lord would want to tell her story about her son who was just 30 years old and was treated like an animal while incarcerated and died. And that's part of the grieving process also. Mm-hmm. And if this settlement is adopted, she won't get that voice. She'll never get that voice. If we apply the but for standard, but for the actions of Carlos Prado, would Mr. Talbot still be alive? I'm sure there would be expert testimony as to that, but we haven't heard of any other actor here that has done anything wrong. Mr. Prado didn't review the medical records or have somebody review the medical records before he decided that Mr. Talbot should be sprayed. Mr. Prado, we learn, sprayed the individual too closely, about 6 inches away, which violated the standard. And I believe all 3 sprays, not just the last one, were oversprays. I believe that's what's indicated by what I reviewed in the file. Once again, Mr. Prado. Mr. Prado kicked Mr. Talbot in the torso area. All of those, Mr. Prado had to do with restraining. Mr. Prado was the supervisor with regard to when the person was restrained in the cell. So you have to ask yourself, but for the actions of Mr. Prado, would Mr. Talbot still be alive? More than likely, yes. I can reasonably assume that a jury would find. The remainder of the defendants, we put them in the other pocket and say, but for their actions, would we even be here today? I've heard nothing about the other individuals. So if the mere action, the but for by the other individuals is break of policy, and that's what the lawsuit has to do with, this case is probably worth taxpayers' dollar about $300,000 to $500,000. And that's probably large in and of itself, because then we got to get the damages, right? So duty, breach, causation, damages. But we look at the other portion, we have the death of an individual. Wrongful death cases, they're large. They are in excess of $1 million, most likely, usually. The balance of this settlement is a result of Mr. Prado's actions. I would have liked to make that call too when I'm representing my client. If the taxpayers are going to pay for your bad acts, you're not going to have to pay anything. We won. At the end of the day, the question is, what is the message that we're sending? The AG's office has made a determination that the actions of this particular individual were wanton, willful, or reckless, leading to a death. Whether the state's attorney's office, their investigation causally made that link, that's a different standard and a different review. We're in the civil context here, a much lower standard. The internal investigation aspect of this, I really don't have a lot of confidence in. You know, I brought up the other day an independent investigation. There's obviously more going on here. But at the end of the day, the question is, should the taxpayers be solely responsible for this number? And my answer is no, it can't be. The number is a large number. And I think if we were all writing the check ourselves, we would be looking at this a little bit differently. We're using taxpayer dollars. I can understand, and I do appreciate the good actions of the Attorney General's office in this case, but you know, I think Prado should be dealt with differently. I think the number should be lower. And I find a lot of difficulty in supporting what we have before us here today. So thank you, Mr. Chairman.
Thank you, Representative O'Day.
Thank you, Mr. Chair, for the second time. But just briefly, you know, I'm looking at section 5-141D. So thank you for pointing that out. I don't any longer practice as much as I used to in municipal defense and state defense type work that you are immersed in. And I've been listening to the testimony, comments. You know, you're between a rock and a hard place, in my humble opinion, having listened and litigated matters for too many decades than Attorney O'Neill and I would probably like to admit. Looking at the statute, you know, we're obligated to defend and indemnify for all conduct within the duties, his duties, or within the scope of his employment, and such act or mission is found not to have been wanton, reckless, or malicious. And I think the problem you're hearing from some of my colleagues up here is that a lot of what you found, or what the case showed, was that the conduct may have been, was likely, much of it, wanton, reckless, or malicious. And so the rock and hard place that you're between is trying to carve out a settlement that takes care of the case and doesn't expose taxpayers to a higher exposure. And as someone who litigates on a daily basis, represents clients in catastrophic type accidents, you know, I think you did the best you could based on what I'm hearing and what I'm reading and what I've read. So I understand my colleagues' concerns, questions, and apprehensions, but we're between a rock and a hard place, as you are. And I appreciate your efforts on behalf of the state and in navigating this rock and a hard place. Thank you. Thank you, Mr. Chair.
Thank you, Representative. Comment, question from members of the committee. Comment, question. If not, Representative Staffstrom.
Thank you, Mr. Chair. And again, my apologies for not being there as I try not to get everybody sick from the flu that I'm getting over. But I think Representative O'Day just made my point, which is I really think the question for this committee is not necessarily but for the message sent, but really the question for us is this settlement fair and just, and is it in the best interest of the state taxpayer vis-a-vis what a jury verdict would return? And so I guess my only question for the Office of the Attorney General is, you know, are we confident that if this case were to go to trial, we believe a jury would return a more adverse verdict against the state of Connecticut.
That's exactly why we're here today, right? We made the determination. Of course, you never know for sure until you go to trial, but we believe we have higher exposure for the other defendants, given their, in some ways, failures to act. And that's why we're here today. And I agree with what you said.
Yeah, I think Representative Day sort of just made this point, but I think the important thing for us to keep in mind here is, as much as none of us want to have to write this check, as much as um, none of us want this to ever happen again, even close to it. I think our determination as a committee is this settlement in the best interest of the state. And if we're worried that a jury will return a significantly worse verdict, then unfortunately we have no choice but to accept the settlement.
Thank you.
Thank you, Mr. Chair.
Thank you, Representative Staffstrom. Seeing no further questions. Seeing no further questions, thank you very much for joining us today. We have some folks who would like to, before we go to the vote, have a discussion. So we're going to set up for a quick caucus, not a very long caucus. And then we are going to come back and have a vote on the resolutions before us. I am understanding that it is 2,600 for the Republicans, and we will send out a message for the Democrats. So
We also have a Zoom link, Mr. Chairman.
yeah, and there will be Zoom links as well. We'll use the Judiciary conference room. That'll work. We'll use the Judiciary conference room for the Democrats. So we'll recess until then. Okay, we are going to call ourselves back to order. And we are going to now have a vote. The first item that we are going to have a vote on is Senate Resolution number 13, a resolution approving the settlement and release agreement in Colleen Lloyd et al. Versus Carlos Padro et al. Is there a motion?
So moved.
Second? No, I'll second it. Senate.
Prerogative of the chair.
It is moved by Senator Kissel, seconded by myself. Is there discussion? Senator Kissel.
Yeah, thank you, Mr. Chair. A lot of disturbing facts underlying this, but fundamentally, I think if it goes before the real question, fundamentally, I believe if this goes before a jury, they're going to want to hammer the state. And you can carve out the one actor that retired after 8 days and say it was all his fault. But there's a lot of other state actors that if they didn't violate criminal laws, certainly they violated policies that were in place at the Department of Corrections. And given the fact, despite this individual's, being out of shape and other health issues, he really was only 30 years old. The eggshell skull theory, you take your victim as you find him. And I'm sure that an actuary in the tables of mortality and morbidity at a life expectancy of several decades still ahead of him. And so you put this before a jury and there's really no defense as far as what happened. They're going to want to send a strong message. And I think Attorney Meskel indicated that the range could be anywhere from $1 to $12 million. And some of my colleagues who have experience in civil litigation with some major cases with deep pocket defendants have said that recently in Connecticut, there's been some extraordinary verdicts in the multi-millions of dollars. So it's a very unpleasant situation for all concerned. We never want to see another death in the future. I have the utmost confidence that Commissioner Quiros will take us in the right direction. And so for those reasons, I will be voting yes in favor of this settlement. Thank you, Mr. Chair.
Thank you, Senator Kissel. Further comment on the matter before us? We're discussing the Senate resolution, so those in the House will have an opportunity momentarily. Further comment, Senator Gakar Wilcox.
Thank you. I just wanted to echo the comments of my good colleague, Senator Kissel, in their entirety. It's a terrible situation, but looking at the situation and as a whole, I'm also voting yes on this, with the hope going forward that we are looking at those systemic problems, and correcting and looking at accountability and transparency and correcting those problems going through. But just echoing basically everything Senator Kissel said. Thank you.
Thank you. Comment or question from other members of the Senate on this committee? If not, I just want to say I align myself with those comments. I have a deep sense of frustration, but I do think, given what is before us and the facts, that a vote in the affirmative is the right vote for us today. And with that, Madam Administrator, if you call the Senate roll.
Roll call vote on Senate Resolution 13, Winfield,
Winfield in the affirmative.
Flexer, Gadkar Wilcox,
Gadkar Wilcox, yes.
Kissel.
Yeah.
Cabrera, Ciccarella, Gaston,
Senator Gaston votes yes.
Lesser, Mar, Miller, Rahman,
Senator Rahman votes yes.
Sampson,
Thank you for that. The votes will remain open until 12:45. So if you know someone who didn't vote, help them to know when they have to vote. With that, the next is House Resolution number 14, It's a resolution approving the settlement and release agreement in the Colleen Lord et al. Versus Carlos Padro et al. Is there a motion?
So moved.
I heard the movement by Representative Vazino. Was there a second?
Second.
Seconded by Representative Osborne. Discussion. Representative Dubitsky.
Thank you, Mr. Chairman. I was just wondering if you might be able to explain why we're voting separately between the Senate and the House on two separate resolutions.
Our LCO's hand immediately shot up. That will allow him to answer the question.
Yes, Representative Dubitsky, this process is governed by Rule 32 in the joint rules. And those rules specify that our office is to prepare separate resolutions on this matter. And historically, that's what's been done with these AG settlements.
Thank you. Thank you, Mr. Chairman.
Thank you, Representative. Representative Fishbein.
Thank you, Mr. Chairman. Many times on this committee, whether you're on House or Senate, I find myself learning, listening, sometimes changing my mind based upon what my Senate colleagues have to say about a particular initiative. So, I think in the future, perhaps if we allowed both sides of the aisle to share our thoughts, because we are inexplicably intertwined, because, I find myself in a damaged position now, having one body already voted. And the argument, well, you're going to upset the apple cart, because the Senate's already made their decision. That being said, it's very easy to vote in favor of this motion if you don't hold the checkbook. Very easy to write somebody else's check. At the end of the day, the state has put together, through statute and regulations, rules. That's our duty. The state has followed its duty. In this case, I think 16 different people have been sued. One individual, everybody is pointing their finger at, who the AG's office has admitted was wanted, willful, or reckless on various planes. I think there's at least a dozen violations of those statutes and rules that this one individual, we're being told, violated, that led to someone's death. And this number, I don't buy the argument that the state defendants and the one individual are inexplicably intertwined for the purposes of trial. I don't see any motion in the file where the AG's office asked to have separate cases or to bifurcate or something like that. That's possible. But we're being told that we have to ride along. The taxpayers are required to ride along in the cart, even though it created statute, it created rule. As far as we know, everybody else followed statute and rule. But this very large number is falling on the shoulders of the taxpayers. The message that we're sending to the general public, to every state worker, do whatever, doesn't matter. We create statutes, we create rules. You can violate them. You have no liability. State will pay the bill, no matter what. This individual was criminally prosecuted. Now, assault third, I don't know here. It's our lowest level physical contact crime in Connecticut. It is a Class A misdemeanor. So when we talk about on this committee penalties, just think about it. He didn't check whether or not the gentleman had medical ability to take the OC spray. He oversprayed on 3 occasions. He didn't decontaminate nor direct anybody to decontaminate. At some level, at some point here, you're well away from Class A misdemeanor. I gotta say. But here, this gentleman pled guilty to a Class A misdemeanor, and the state is paying $3.75 million for his bad acts. I can't support it. I don't know how anybody in good faith could support it, with all due respect to my colleagues. So I do intend to vote no. You know, as I said before, I think the liability for the actual state actors that are being defended by the states by the Attorney General's office is well less than $1 million based upon the damage calculation. We have a duty here, and I intend to follow my duty. So thank you, Mr. Chairman.
Thank you, Representative. We'll next have Representative O'Day, followed by Representative Osborne.
Thank you, Mr. Chair. I rarely disagree so vehemently with my good ranking member. And I didn't stay at a Holiday Inn Express last night, but I do litigate death cases on a regular basis. And I completely disagree with my good ranking member, who I respect immensely. Not only on the substance of his dissertation of the facts, but also in his opinion that in good faith he can't understand how anybody would vote for this. I am going to vote for it on a number of reasons. I litigate death cases regularly. And while the number is large, I've seen a number of death cases where the verdict comes out higher. But without even getting into the specifics of this case, which are horrific on many levels, I trust the AG's office. And I did say that I know Attorney O'Neill for decades. They know this case better than we do. They've litigated this case. I litigate cases, and if you were to try and look at all my cases that I've settled, I'm sure you could pick apart why I paid too much or my clients paid too little. But I lived the case. I trust the AG's office. I trust the attorneys that came before us, that come before us from the AG's office. The vote here is whether or not we believe the Attorney General's office did the best job they could in negotiating the settlement. In looking at it, I think they did. And so, I respect my good ranking member immensely, but I disagree with him vehemently. And I'm going to vote for this because I trust the AG's office. And in looking at this case, I think it's in the taxpayers' best interest to settle this case. And what I heard here in the testimony was that the Department of Corrections has changed policies and procedures in investigating, and they're going to do what I heard was they're going to do everything they can to make sure this never happens again. So I'm going to vote for it, and I urge my colleagues to vote for it as well. Thank you.
Thank you, Representative Osborne.
Thank you, Mr. Chair. And I'd like to, publicly align myself with the good comments of the good Representative O'Day, both in substance and in form. Certainly the comments of Representative Fishbein, good ranking member, would be the only arguments that could be made on a defense of this matter. And certainly a settlement on this will bring no measure of cure to the family, but it will bring some closure, at least as to this one particular phase. And there's value to that for the family, and there's value to the state of Connecticut for bringing this to a close. And as an attorney who has some experience with these types of awards, I think that an affirmative vote here, for all the reasons I've mentioned, is the right vote. And I will be supporting this bill, and I urge my colleagues to do so as well. Or this resolution, excuse me. Thank you, Mr. Chair, through you.
Thank you, Representative. Are there further comments on the bill, the resolution before us? Further comments? Seeing none, Madam Administrator, would you call the House roll?
Roll call vote on House Resolution 14. Staffstrom,
Staffstrom, yes.
Fazino,
Yes.
Fishbein,
No.
Blumenthal, Brown, Callahan,
Callahan, yes.
DiCaprio,
DiCaprio, yes.
Delaney, Dillon,
Dillon, yes.
Doucette, Dubitsky,
No.
Elliott, Gilchrist, Godfrey, Howard,
Howard, yes.
Jacobson, Johnson,
Johnson, yes.
Khan, Lamarck Muir,
Yes.
O'Day,
O'Day, yes.
Osborne,
Osborne, yes.
Havelock D'Amato, Quinn,
Yes.
Roberts, Retigliano, Sims, Veach,
Yes.
Walker, Wilson,
Yes.
Thank you, Madam Administrator. And as stated before, the votes will remain open until 12:45, but don't leave because we have more. All right. See you all at 1.
Madam Administrator,
yes, Representative.
I Doucette votes yes.
Thank you so much.
Madam Administrator,
Yes, sir.
Delaney, yes.
Thank you so much.
Thank you.
Hi, Representative Jacobson, can you hear me okay? I'm ready to take your vote when you have a sec.
Yeah, of course. You can hear me.
Yep. How would you like to vote on House Resolution 14?
Is it just, well, how did the chairs vote, may I ask, please?
And support.
I'd like this vote consistent with the votes of the chair.
Okay, you're all set.
Thank you. Are we on at 1 o'clock as well?
Yes, yep, 1 o'clock.
Thank you kindly.
Thanks.
I'm actually just gonna keep it on the background, right?
Hey, Senator, can you hear me okay? Hang on. Wait, you're mute. Nope, you're muted.
Hi there, sorry.
No worries. How would you like to vote? We have one resolution, the Senate one, SR 13. How would you like to vote?
I am a no.
Okay, you're all set. Thank you so much.
Thank you very much. Have a great day.
You too.
Bye.
Hello, Christian.
How are you, Representative?
I'm good, thank you.
How would you like to vote for House Resolution 14?
Yes,
Okay, you're all set. Thank you so much.
thank you. Take care.
Thank you.
Kirsten, I was late to unmute when you called the roll. You got me though, right?
Hello. I missed what you said. Sorry, Representative.
No, that's okay. It's my fault. I was late to unmute. I'm used to having the Senate, so I thought I had more time.
Oh.
But you got my vote?
Yep, you're all set. I got you in the affirmative.
Thank you. I'll see you in a few.
Okay, sounds good. Hey, Representative.
Hello.
We had one vote. We had them split obviously by chamber. So House Resolution 14, how would you like to vote?
Yes.
Okay, you're all set. Thank you so much.
Thank you. And then is this the same Zoom or do I come on a different one later?
A different one for the next one.
Thank
Yep,
you.
you got it.
That's a me thing. Yeah. How you doing?
Hi, good, thanks. How
I
would you
went
like
to
to
the
vote
wrong.
on House Resolution 14?
Yes, please.
All right, you're all set. Thank you.
Thank you so much.
In a bit.
All right, bye-bye.
Hey, Senator.
Hey, how are you?
Good, good. How would you like to vote on Senate Resolution 13?
Yes,
Okay, you're all set. That's it.
thank you.
Thanks. Hey, Senator, how are you?
Hello, Kirsten. How are you?
Good, good. How would you like
Good.
to vote on Senate Resolution 13?
I vote yes.
All right, you're all set. Thank you so much.
Thank you.
Hi, Senator.
Hello, how are you? Just want to make sure I didn't miss anything.
Nope, you're all set. I got you for the one vote.
So they're not meeting again?
We're going to start our public hearing at 1, and then we'll have a meeting right after that. So when we
Okay,
have
sweet.
those votes, yep, we'll send all the stuff out. That way we let you know what, how long those will be held open.
Okay, thank you so
Okay.
much.
Of
All right,
course. Thank
bye-bye.
Madam Administrator,